Hello and welcome to Ottawa Business Journal's coverage of the COVID-19 pandemic. My name is Michael Curran, the publisher of the Ottawa Business Journal. In order to keep local business leaders informed, OBJ is conducting a series of video panel discussions with local business experts. And today we turn our attention to contract law at a time of COVID-19. Let me introduce our panel of legal experts. First, we have Megan Wallace, a business lawyer with Perley-Robertson, Hill and McDougall. Hello, Megan.
Hello, thanks for having me.
It's my pleasure. Chris McLeod, head of commercial litigation for Mann Lawyers LLP. Hello, Chris.
Hi, Michael. Pleasure to be here.
Thank you once again for joining us. And finally, Andrew Foti, the founder and principal of Avokka Professional Corporation. Hello, Andrew.
Hi, Michael. Great to be here. Thank you for having me.
Yeah. So let me paint a little bit of a scenario that I suspect is playing out across Ottawa's business landscape, and it goes something like this. Businesses have relationships with clients and suppliers. More often than not, these relationships, of course, take the form of a contract. Contracts would normally have things like price and payment terms, schedules, and other clauses. And business owners, I bet you, on an hour or certainly day-to-day basis, are getting these questions. Can I cancel this contract? Can I delay this contract? So Megan, why don't we start with you a little bit? And the big question, I guess, is, are business contracts enforceable during a global health and economic crisis?
I mean, a broad question, and the answer will always be it depends on the facts and precisely what's happening. Generally speaking, it would really depend on the nature of the contract and what it's for and whether performance is still possible. What I've been dealing with a lot at work is clients that have planned either annual meetings or events and are now working with hotels and suppliers to try to terminate those contracts. So I'm sure the lawyers for the hotels and the third-party contracts are also dealing with people trying to cancel on the other end. So there's no strict rule that says because the WHO has declared a pandemic, contracts aren't enforceable. You have to go to the language of the contract, what it's for and what it provides for in respect of force majeure and termination and things like that.
So let me just pick up, Chris, we'll go to you next. Let me just pick up on something that Megan said. So if I'm the business owner and I'm still prepared to deliver that product or service, should I assume that I can enforce the contract?
Yeah, so picking up on what Megan said, contracts are still presumptively enforceable. And the question is whether there is some reason that they would become unenforceable, either by virtue of a clause inside of the contract or by virtue of some sort of application of common law principle like frustration. But contracts are still presumptively enforceable. I think because of COVID-19, there's a broader number of tools in the tool belt in order to try and escape from contractual obligations, but presumptively they're still enforceable. And Megan brought up a good point about force majeure provisions and frustration. That's a very tricky area of the law, and it's something that hasn't been seen in this context in any of our lifetimes. So we're basically we're left interpreting broader principles to the specific circumstances now, and it may be that COVID-19 provides a way out of contracts, and I think that in many circumstances it will, but it's going to depend on the specific circumstances.
Andrew, I want to give you an opportunity to weigh in on this. So if you were speaking to a client this afternoon, and they said, Andrew, I've got clients calling me and saying they want to cancel their contracts, what kind of general advice would you provide them, Andrew?
Well, I think that the first order of business is to look at the contract, as Chris and Megan have indicated, to determine whether it has force majeure language. A lot of contracts, it's interesting, our inclination is usually to read past all that boilerplate, and now people are going to the boilerplate and saying, is it there? So first question is, do you have a force majeure clause? And the second question, we'll talk about how that's interpreted. The second question is, if you don't have a force majeure clause, what would frustration look like? And I would really be saying to the client and the business owner, well, so what answer do you want? Do you want to perform? Can you perform? That's really the threshold question as to whether, from an outcomes perspective, what does the client want to do? Because generally, as Chris and Megan have noted, there's some room for interpretation here. So do you have a force majeure clause? Yes or no? If no, is it possibly a frustrated contract? And in Ontario, for example, apart from the common law, there is a statute on the books called the Frustrated Contracts Act that provides for what happens in the case of frustration, which is basically the impossibility of performance by virtue of unforeseen events. So my question to the client would be, okay, you don't want to enforce, there's no force majeure, you don't want to perform, but you can perform. Was it foreseen? It would depend, as Megan has said, on the circumstances. Are we in the emergency services business? Well, then I don't think we're out. Are we in something else? So it's highly varied, it's situational, but I'd start from that cascade as a sort of a series of questions to determine what to do in each particular circumstance.
And Megan, let's go back to you. So let's just zoom out a little bit. So I, for one, I've been in business for a few years, and I've seen this term force majeure, and quite frankly, I've glossed over it, right? But if I ever had put my thinking cap on, I would have thought that looked like a tornado or a flood, or there was a fire in my building or something like that. But let's just zoom out and give people a broader context of, where does this term come from?
I mean, it's a term that means is referring to an event beyond the control of either party that makes performance of the contract impossible. So it's speaking of things that are beyond our thought and our skill. It wasn't expected, it's popped up. Interestingly, I mean, maybe to the lawyers on the call and nobody else, but interestingly, it is one of those things where you have to specifically list the different events. So when you're interpreting a force majeure clause, if it says tornado and doesn't say pandemic and doesn't have language that you could argue that it included a larger scope of events, then you're looking at impossibility or frustration, like Andrew was saying. It's also, I think, really important for business owners to note that where performance of the contract is not precluded. So if I'm supposed to be preparing you, a book of documents, and I can do that from my house, that will not trigger your force majeure. It has to be based on the fact that you cannot perform the contract.
Okay, and Chris, again, just to zoom out a little bit, you've operated, you've been working in business law for many years now. In normal circumstances, would you ever be talking to clients about force majeure? Like, is this something that would be part of regular discussions if you're talking to a client about a contract dispute?
Sure, it can be. And take, for example, a party's got an event booked in a facility, and the facility burns down, right? Then you're going to be talking to them about whether there's a force majeure clause in the contract or whether the contract is otherwise frustrated. Just to jump back a little bit to something that Megan said, this is a really important point. Force majeure is not a generally applicable term. It finds its basis in the contract between the parties. So you will either have a force majeure clause or you won't. And the scope of your rights and obligations under that, in the event of a force majeure, is captured within that clause. So as Megan said, if it only says tornado and something else happened, you may not be covered. Typically, the way they are worded, oftentimes you see words like epidemic in there, maybe not pandemic. I'm not sure that I recall seeing that one before, but there can be catch-all language in there, things like other government action. So does that trigger your ability to exercise your rights under the provision if the government shuts down public events and you were scheduled to have a public event? It might do that. But importantly, your rights under the force majeure provision can also contain obligations. So if you do take the position that you're exercising your rights and terminating the contractual obligations under the provision, you may have obligations under that provision as well. You might have to put the other party on notice. You may have to do certain things before you can avail yourself of that of those rights. So it's really important to look at the provision, understand it, and if you if you don't understand it, talk to a lawyer, frankly, to help you understand what rights you have and don't have under a force majeure provision. Frustration, which has come up, is something different than the contractual obligation between parties.
Andrew, I just picked up on something that Christopher said, and maybe you could help clarify this for me. So if I'm a business and I'm in a situation where I can continue to deliver that that goods or service, is it important for me to communicate that to my client? Is that going to help potentially in weeks and months down the road when potentially we're looking at whether a contract is upheld or an invoice gets paid?
It will depend on what outcome you're looking for. Are you looking to perform? Is it a revenue contract? In which case you probably are, and it would be important to communicate that we stand ready to deliver. For example, you'll notice on my email, there's a COVID-19 notice on the bottom that says, we're here, we've always been here, and we're still here. So you absolutely should do that if it's revenue contract. On the supply side, it becomes a question of getting the supplier to say that whether they can or they can't. I think that is very important. It's an insightful observation on your part. But again, these statements, and Chris will probably weigh in here, is that for litigators, these statements are the evidentiary trail that will determine what's going to happen in those contracts. So you want to think carefully about the outcomes that you want, and then move accordingly. There's one thing we haven't touched on, if I may, that's important. We've been talking about contracts in a supplier kind of customer relationship. An important element for businesses to canvass that they may not have canvassed are their insurance policies, business interruption, travel insurance, and the like. There, to pick up on what Chris has been saying, wording is critical, and they vary surprisingly from contract to contract, from insurer to insurer. And so it's critically important to look at the wording of those clauses, because businesses may be able to take advantage of business interruption insurance. They may be able to take advantage of travel interruption or travel cancellation insurance, depending on the wording of the policies. A lot of those have now been changed to provide a COVID-19 exclusion, but prior to those changes, they may be available. And I will tell you that I've invoked several for clients already in the past week.
Okay. Megan, we're going to start wrapping up, but I just want to ask you this question. So, of course, in a business relationship, whether it's a client or a supplier, there is always the legalities that surround that relationship, but there's also, maybe I'll call them the practicalities around it too, especially as we were saying, we're living in unprecedented times. Yeah. So can you speak to that a little bit in terms of, there is legally what this contract says, and then there might be some practical considerations if, for example, I'm dealing with a client?
Yeah, I mean, it's interesting. I've been dealing with clients who are trying to kind of move or cancel meetings or events, and working with hotels, and the tone has really changed in the last week, as I think everybody has seen in every facet. The news is different. We're all moving minute to minute on what's going on. But after the first few days, what I kept saying to clients, the fundamental approach is be nice and do your best. Because it is important, I think, one, to be kind to each other and behave like decent human beings, step one. But also, you're going to be wanting to do business after this passes. And if you behave, rudely or meanly or unkindly, I think you need to be concerned about your reputational risk going forward. That's not a legal analysis, but to me, that's where people, they need to focus on being kind and doing the right thing, step one. But they also need to realize that they're going to be in business and maybe wanting to do business with these people later. So you can insist on strict performance if legally you can, but is that going to be perceived negatively by the public or by people you're in business with, 6 months down the road? And I think that is an important consideration.
And Chris, just give you an opportunity to weigh in on that. Anything versus legal versus practical in terms of suppliers or clients?
Yeah, thanks. Just picking up on something Andrew said, I think it's important that everybody understand when it comes to force majeure provisions that they're not there to be exercised when things are inconvenient. So if something is more expensive to deliver now because of COVID-19, it's not likely going to hold up if you get before a court. It really needs to be impossible. That's the purpose of this. Courts typically want to hold parties to their bargains. So it's not something that should be done lightly, and it should be done, frankly, with legal advice. As far as the practical side of things, you're absolutely right. I mean, these are unprecedented times, and I'm sure everybody on the panel has clients that are simply fighting for their corporate existence right now.
Yeah.
With this thing, and there's very, very difficult strategic decisions that need to be made. And obviously we give them the lay of the land so that they can make the business decision on their own. And I take Megan's point about certainly reputation going forward and long-term prospects of doing business with suppliers or customers is one of the factors to be looked at. But frankly, what I'm seeing from some businesses right now are more fundamental decisions that are being made. They're picking and choosing perhaps who's getting paid and who's not to try and stay alive, and who's getting paid and who's not to try and avoid taking on personal liability as directors of companies. So there's a lot that goes into the mix right now. It's not easy times. And it's complicated for clients.
Andrew, I'm going to give you the final word, and I'll just open it up even more broadly. Andrew, is there anything else, just in kind of a minute that we have left, that you would suggest that business owners be thinking about from a commercial law perspective? We did cover, I should point out, employment law in a previous video, so maybe leave that out. Is there anything other aspect of contract law or dealing with clients or suppliers?
Well, apart from the insurance point and the employment point, which you mentioned, and the employment point is important because of some very big changes that came out yesterday, perhaps after your call, with respect to payroll deductions and the 10% for small business employers. That's critical. So everybody should be re-looking at their calculations on what they can get from the federal government in terms of a 10% pop on employees that they're paying. To Chris's point, you should be looking holistically at the business and saying, what are the revenue risks? What are the supply risks? What can I live without? Do I need to shrink my team? If I'm shrinking my team, from an employment perspective, do I have contract language that allows me to do that? Look at insurance policies because a lot of the travel is recoverable. And I would say, as a practical matter, I like very much what Megan said. I mean, this is a tough time, and we have to be kind to each other. And notwithstanding that we're lawyers, lawyers can are best left in the back room, I would like to say, mostly. Work on the relationship. Talk about impossibility. Know what you want. Inventory what you've got. Decide what you want to do, and have conversations. If the conversations don't result in what you're looking for, move the conversation upward progressively without any kind of saber rattling or lawyers involved, with the advice in the background, obviously. And only when you get to a point where something's pivotal that you must have or can't do, and you're not getting where you need to get to after escalated all the way, then do you move to this kind of language where you're looking at whether you have a force majeure clause, whether you don't have one, or if you do, what it says. If you don't, whether frustration would apply. And it becomes very situational at that point. But that, to me, is the method of dealing with this. It's really a holistic assessment. And to finish off with Megan's point, be nice. Because really, at the end of the day, we've all got to deal with each other down the road. And that's really what it comes down to.
Yeah, such a good point, Andrew. I often say that, Ottawa's like a big village, right? So there are so many tight connections between us. It forces us to behave.
It's a good thing.
Yeah. So listen, that's all the time we have. It's been a great discussion, very practical advice. I want to thank once again Megan Wallace, a business lawyer with Perley-Robertson, Hill and McDougall. We have Chris McLeod, head of commercial litigation from Mann Partners, LLP. And of course, Andrew Foti, founder and principal of Avokka Professional Corporation. I do, of course, want to point out and emphasize that you should consult a lawyer on these issues, and that this video does not constitute legal advice to you. Please stay tuned for more of these video panel discussions next week. You can visit obj.ca or go directly to our YouTube channel and look for the Coping with COVID playlist. Thanks again. That's all the time we have for today. Everyone stay healthy. Bye-bye.
Thank you.
Thanks very much.
Thank you.